Hi, cybersecurity class. I wanted to give you some materials and some thoughts on the materials that I gave you to read this week. And we're really diving this week into the beginning of thinking about how our ideas about civil liberties relate to these questions of national security in cyberspace. And we really begin to kind of lay the groundwork this week. And then next week we really dive into what I think is the core of the question as it relates to national security, which is mass internet surveillance, which was disclosed by Edward Snowden, and as to which there's been lots of developments over the years since then. But there's a couple of other things that I want to talk about before we get there, including questions about debates about encryption, which are continue to be hot topics in the news and continue to be issues that float around these questions of cybersecurity and national security. So the first piece is just a little bit of a reminder when we're talking about civil liberties in this context. We're mostly talking about criminal procedure and the ability of the government to engage in search and seizure. And as well, there's a kind of subsidiary issue that I gave you one of my papers to read that we'll talk about, which relates to the ability of the government to compel the disclosure of information about encryption. So recall that the Fourth Amendment within the Bill of Rights is the provision against unreasonable searches and seizures, and further requires that warrants issue on probable cause. So unreasonable search and seizures and warrants issue on probable cause, and the warrants are supported by evidence that describes the information. The Fifth Amendment, if you'll recall, deals with double jeopardy, in the indictment provision of a grand jury, and the provision that no one needs to be a witness against themselves. That is the privilege against self-incrimination, and further includes the due process clause that is within the Bill of Rights. Of course, there's a due process clause in the 14th Amendment, and we know all the jurisprudence about privacy that relates to. So as you can see from this slide, really the debate that we're talking about dates back at least to the beginning of the early public internet era. And as this slide suggests, I think of that era as really the early to mid 1990s, when the internet is first becoming available for public use, and when tools are beginning to be released like the World Wide Web and search that are allowing ordinary people to have more access to the internet. And even then, there are concerns from law enforcement about the ability of encryption technology to keep communications and other information secret from law enforcement. And there are a whole number of debates about encryption technology and filtering technology from that era, and a number of proposals that were suggested for government access or backdoors or other things like that involving encryption really were not adopted or did not succeed from that era. So there is kind of this early public internet era already discussion about encryption. I should say, going before that era, in the era of the telecommunications regulation of long-distance telephone service and the growth of, before voice over IP, television service, there was a statute adopted by Congress called the Communications Assistance for Law Enforcement Act, or CALEA, which did require telecommunications carriers to build into their systems the capability for government, with a proper warrant or court order, to access those systems for the purpose of wiretaps and for the purpose of pen registers and trap and trace orders, which is the ability to determine the numbers that have been dialed. That legislation did not prohibit the use of encryption by telecommunications providers, but it did require telecommunications providers to be able, upon the service of a valid warrant, to make information available in non-encrypted form to law enforcement. So you have kind of some of the foreshadowing of it there, although as it moves into the internet, the debate becomes different, and the debate today is different because the kinds of information that a carrier or a provider like an ISP might hold, or that a service provider like a Google might have, is much more extensive and much different than what a long-distance provider might hold. But that is still part of the debate and still informs it today. This debate in kind of more recent history really came into sharp focus again after the terrorist shooting in San Bernardino and the effort of law enforcement to get into an encrypted iPhone that one of the shooters used. And if you recall that debate, Apple resisted orders that the government had sought after serving a warrant for Apple to give it assistance to get into those devices. And that issue too, the question of whether a device provider needs to give assistance to law enforcement, whether Apple, for example, or Google needs to give assistance to law enforcement to get into an encrypted device that provider supplies, is also still a very live debate. But that's one piece of it, and it became bigger in that debate. So during that time, Senators Burr and Feinstein introduced a bill which would have said that any covered entity, including a device manufacturer like Apple, upon receiving a court order, would be required to provide the information subject to that order, including a warrant, in an intelligible format, or otherwise provide technical assistance that would enable the government to obtain that information in an intelligible format, and it would require providers to design their equipment in such a way that they could satisfy the intelligible format requirement. The Burr-Feinstein bill was widely derided in the tech community, and it was widely derided in the sort of cyber law community, particularly because, well, for a number of reasons, but particularly because this final provision really would have effectively outlawed certain kinds of encryption. And I'm going to, in a second, talk about different kinds of encryption. And so it is certainly problematic by all accounts to have a bill that would effectively outlaw certain kinds of encryption or make the encryption useless by providing sort of a universal backdoor to government. I personally think that there are some possible solutions, and I give you in another one of my papers sort of for this week and my thoughts on this. I am actually a bit more law enforcement friendly, I would say, than most cyber law scholars on this issue, but I do agree with the consensus that the Burr-Feinstein bill, as written, was a bad idea. All right, so let's talk a little bit about encryption and how encryption works. And we don't need to get too much into technological details, but we do need to have a little bit of an understanding. So first, a little bit of terminology. Plain text is unencrypted text that is readable by a person or a machine. So just the text you're looking at here on the screen is plain text. Ciphertext is encrypted text that is not readable without a decryption key. So once the text is encrypted, and a human being can't read it without having a decryption key that changes it back into plain text, it's called ciphertext. A decryption key is an algorithm that allows ciphertext to be translated into plain text. Now, all this sounds really high-tech and complicated, and of course, with a good encryption algorithm, it can be, but it doesn't have to be. And really, all encryption is taking plain text, applying some kind of algorithm that changes it into ciphertext, and then having a key that can change it back, perhaps by reversing the algorithm, into plain text. So here's an example. It's a really bad algorithm, but it actually is used on some internet message forums as sort of a default or a first cut at a loose kind of encryption, and it's called ROT13 or Rotate 13, and all it means is that you're going to take the letter in the alphabet and you're going to rotate that letter 13 places. And if you think about that, there's 26 letters in the alphabet, so you can rotate it 13 places in either direction, and you're still going to come up with a ciphertext that then is going to be relatively easy to sort of discern and decrypt. So here's an example from a site that does ROT13, and if you see, I just type in my name is Dave, and it translates it through the ROT13 algorithm into text that is otherwise seems meaningless. Now, of course, if you take a guess that ciphertext is ROT13, you could, on a piece of paper, pretty easily decrypt it, which is why it's not a very good algorithm. But you can see the basic principle there. Now, I mean, kind of commercial grade encryption, including things that are widely and cheaply available. I mean, if you have Windows, a current version of Windows, you have built into your operating system BitLocker, which is I think it's a 256-bit encryption algorithm, which is effectively unbreakable by raw computing power alone. And again, really inexpensive. Basically, if you have Windows, you have it. I use it on the external hard drive that I put my Google Drive folders onto that I use for my work here at school and for consulting work, so that if anybody tried to stole that external drive, it would be a brick. They wouldn't be able to use it. Okay, a couple of other terms we want to think about here. So data in motion is data that is in the process of being transferred from one party to another. Data at rest is data that's in storage that's not currently in the process of being transferred. Forward secrecy. Forward secrecy is a kind of encryption that generates a unique key for each information exchange. It's used in to dynamically encrypt information in motion. And each time there's a communication session, you're engaged in a chat session, for example, with someone, a key is being generated that is unique to that session. Why is forward secrecy useful? Because if you compromise that session, if that session key is compromised, if someone is able to kind of break into the start of that session and take the session key, they will be able to spy on, to decrypt that communication session, but only that session, because the key only relates to that session. Whereas if you have a universal key, and I'll show you an example of where you have a universal key, if you get the key, then you can decrypt all of the information. This is important, and this is one of the reasons I think the Burr-Feinstein bill was really badly written, because there really is no way to build into a forward secrecy system a universal ability for a third party such as the government to be able to decrypt the information. Effectively, what you'd be saying is you can't have forward secrecy, and effectively that would really do away with the possibility of having a useful encryption of data in motion. And that would be a bad policy, I think widely agreed. I mean, yes, this kind of technology is used by bad guys, but it's used routinely by sort of ordinary people for very good reasons. Encrypting a business conversation that involves strategy or trade secrets, to encrypting a conversation that just involves personal information, to civil rights activists. There's all kinds of good reasons to use this technology. It has many benefits, and I don't think it's worthwhile to just outlaw. Okay, so here's an example of something that does not involve session keys, but it's a basic concept of encryption that can be used for data at rest or data in motion, often used for kind of data that's being exchanged maybe by email or something like that. And it's called public key or asymmetric encryption. And when we're talking about encryption, we often use the sort of characters of Alice and Bob, A and B. kind of like Abel and Baker, but we tend to use Alice and Bob. So Alice is sending plain text. She's going to send this text to Bob. Now, what Bob has a public key, public encryption key, that he's going to share with anybody who wants to send him information that is going to be encrypted. So Alice has Bob's public key. She's going to take the plain text she wants to send to Bob, and she encrypts it with Bob's public key, and therefore it becomes ciphertext. It is sent to Bob, so as it is in motion, and then when it is received by Bob at rest, it is ciphertext. Bob then has a private key that is able to, sort of the other teeth on the key, so to speak, or other teeth on the lock, I guess you could say, that is able to then decrypt the information that was encrypted with Bob's public key. And that then turns the information back into plain text that Bob can read. So only Bob has Bob's private key, and or someone that is highly trusted by Bob. If Bob's private key gets out, then any information that was encrypted with Bob's public key will become accessible. So this is a very useful system. It's a very good system, but it means that Bob has to be very careful with his private key. So here's a schematic that's an example of how forward in secrecy might work. So here we have Alice, who is going to send the plain text to Bob. Alice has her own private key, and Bob has his public key and his private key. So Bob is going to send Alice his public key. Alice is then going to encrypt the plain text with her private key, and then she's going to encrypt her private key with Bob's public key. The message is then ciphertext, which includes the message itself, as well as Alice's private key, which has been encrypted with Bob's public key. That whole package is then sent to Bob. Bob is then decrypting Alice's private key, and then is using Alice's private key to decrypt the information and then to read the information as plain text. Why does this make a difference? It makes a difference because with forward secrecy, every time a new communication session is initiated, there is a new private key generated for Alice. So that if this session is compromised, if Alice's private key is compromised in this particular session, or Bob's private key is compromised in this session, then yes, the information in this session will be available, but only this session, because each time there's a new private key for Alice generated. All right, so that's a sense of how a couple of different, and there are other kinds of ways of doing encryption, obviously, but these are some basic ideas about common ways of doing encryption. Now let's think a little bit about data at rest on a computer system. And this little schematic here is kind of a representation of a personal computer system, a Windows-based personal computer system. So when you look at this system, you have a number of layers. You have a hardware layer, which is the devices, the hard drives, the screen, the keyboard, and all that kind of stuff. You have the application program layer, which is higher up in the layer stack here, which are things like the software that you're using right now to watch this video, or your word processing program, and so on. You have the operating system. We're talking about Windows here, so in this case Windows, and the operating system is really providing kind of hooks, so to speak, for the application programs to be able to interact with the hardware layer, and for the hardware layer to be able to interact then with the devices like keyboards and so on that let you do things with the system. And then you have user-generated content. So this video that I'm making here is a piece of content that is user-generated content. You also have a layer between the hardware and the operating system, which is called the BIOS. So you need to have the BIOS layer because when you first are firing up the computer, you're turning it on, the hard drives are spinning up, or in the case of solid state drives are being read, becoming active, and the operating system has not yet been loaded and is not yet talking to that hardware. So there are some bits of code that are encoded into chips on the hardware that are then allowing the as the hardware is being turned on to begin to communicate with the operating system and to kind of turn on those devices, to read them, to check them, to load up the operating system. And if you've ever had sort of a crash of your Windows operating system, you might have had the experience of having to go into the BIOS and load it up in safe mode, or maybe if you've added a new drive or something, there's been a problem, you might have had the experience of going into the BIOS to tweak some of those instructions. So in the hardware layer, we have hard drives, and on the hard drive, we have, unless we're using encryption, files that are unencrypted, that are stored in a format that can be that will be loaded up and read in plain text. And one kind of option here is to say I have a particular file or set of files that I want to encrypt, and you can do that and just encrypt certain files. So I have a drive with maybe a large number of unencrypted files and maybe a smaller number of encrypted files. So that's possible, you can do that. But really sort of the bigger question and the bigger issue for law enforcement is you have a hard drive that as it is being booted up is being subject to encryption algorithms that interact with the BIOS and that then encrypt the entire hard drive. That is what BitLocker does, or something you can configure BitLocker to do, for example. And this is called full disk encryption. So when I talked about my external hard drive that I use to store the information that I have on Google Drive, that drive, as my system is being booted up, my BitLocker is configured so that that entire drive is encrypted. And then if I want to read any of the files on that drive, I have to log into BitLocker and type in a password, which I have selected, which then seeds or triggers the decryption key that then decrypts the files on that drive and makes them accessible. So full disk encryption is a really useful technology. As I've been discussing it here, you can use it for business purposes. I mean, I have files from consulting work that might be attorney-client or otherwise confidential. I have information relating to my work at school that might be protected by FERPA or that otherwise I don't want people to see. So I want that drive to be encrypted. The problem is when a suspect in a criminal matter is served with search warrants for hard drives that they have in their possession, and there's probable cause to believe that those drives contain information relevant to a crime that has been committed or that may be committed. If the drives are encrypted, then law enforcement cannot access them. And the question becomes, should the suspect be required to turn over the password or the decryption key that would allow law enforcement to access those files? And that raises a really interesting question about self-incrimination under the Fifth Amendment. So again, recall the Fifth Amendment, which has the provision against self-incrimination. As I discuss in the paper that I gave you to read, the issue here really comes down to some case law about something called the Foregone conclusion doctrine, or the foregone conclusion exception. This is a sort of rule or exception or doctrine, whatever you want to call it, that goes back at least to Fisher v. U.S. in 1976. And the question is, in that case, is a search warrant that is asking a suspect to turn over documents or papers that are claimed under the warrant to be relevant to the criminal investigation. And the suspect says, I shouldn't have to turn over those papers, because in turning over those papers, I am admitting that those papers are in my possession and control. So I'm admitting some fact about the papers, which is effectively the defendant in that case said a kind of testimony. And the court said, no, that's not a Fifth Amendment problem, because the government already knows that the suspect has the papers. The warrant is asking for papers that are in the suspect's possession. So to the extent there's any information disclosed about the papers and them being in the suspect's possession through the turning over of those papers, that's a foregone conclusion and not a Fifth Amendment violation. After Fisher and around Fisher, there are lots of different cases talking about the requirement that a criminal suspect pursuant to a warrant turn over some physical items or something else like a kind of physical item, and whether those things would be akin to testimony that could be self-incrimination. And all of the things on this list, blood samples, handwriting, voice example, fingerprint, standing up in court, making a gesture, all of these things the court has said are not testimony and do not implicate the Fifth Amendment right. Again, you're assuming that there's a warrant that has been issued based on probable cause. The Fourth Amendment question's been satisfied. We're talking here about the Fifth Amendment. There's an interesting analogy. Justice Stevens, really in the whole course of this doctrine, is one of the justices who is pushed against this kind of narrower reading of the Fifth Amendment. U.S. v. Hubbell was a case involving Webster Hubbell during the Whitewater investigation in the Clinton era, who received a warrant with a very broad request, kind of a broad and general request for documents. And Justice Stevens in that case said, well, this really kind of broad amorphous request requires the defendant to go through the set of documents and identify specific documents, and this then becomes more like not turning over a physical key that would open a safe, something physical as opposed to testimony, but it would be more like taking the contents of the defendant's mind as to what the combination to the safe is, which would be then a form of testimony. So this sort of key combination metaphor floats around in all of these cases, although it's really dicta in the Hubbell case. It still is kind of an important distinction. So in my paper, and in some of the scholarship on this, we kind of get into the question of, well, if we take that key combination metaphor, or if we otherwise look at the question of what is testimony. If it's a right against self-incrimination, it's a testimonial privilege. What is really testimony? And there are a bunch of different kind of discussions in the paper about what testimony might mean, and I kind of have my own proposal about semantic theory and what is the sign from the information that is signified. And I talk in my paper also about some analogies about really the question of computer code, because a decryption algorithm is just code. It's a coded algorithm. Of course, the password that the individual might provide is a little bit different than the code itself, but it's something that triggers code. And there are other areas of the law where we really wrestle with the question of when is code speech or not speech. And my conclusion in the paper And you see I discuss a bunch of case law in the different circuits about whether or not this kind of compelled decryption should be allowed. I say the reading that would say this is in some way testimonial is incorrect, and that in fact the foregone conclusion exception should apply, and that supplying a decryption key or a password that unlocks a decryption key is not testimonial. That the real issue here for me is the Fourth Amendment and whether a warrant might be too broad, and that's its own issue. But if the warrant is proper, then the defendant should be compelled to have to decrypt the drive. Now, that's a controversial conclusion. I think it's a place where I am a little more pro-law enforcement than most cyber law scholars, and certainly than any cyber civil liberties group like the Electronic Frontier Foundation. In fact, I first got into this issue, I wrote an amicus brief in a case in Massachusetts for the Massachusetts State Police Association, and really against an amicus brief filed by the Electronic Frontier Foundation. And I admire that organization. I just think they're wrong about this issue, but they think I'm wrong. So maybe I am. And it'll be one of the things that we'll discuss in the discussion boards next week.